So far we have discussed 52 questions, okay, from Polity of Sankar IAS, this series. Okay, so we are starting our discussion today from 53 questions. Okay, so the first question of discussion is the which of the following situations averages the provisions of protection of interest of minorities provided in the Constitution of India. So average, okay, average means that there is a bridge and you are blocking that bridge, okay, so that is called average. Okay, so it is a negative connotation. Let us see, setting up university for promotion of majority language. No. A refusal to admit a child to an education institution on the grounds of birth, place of, no, this is not. So both of them are incorrect, so neither one or two. Let us see the discussion. So basically, Article 29 of the Indian Constitution grants protection to both religious and linguistic minorities. Okay. However, the Supreme Court has clarified that the scope of this article is not limited to minorities alone. The use of the term section of citizens includes both majority and minority groups. Therefore, setting up of a university for the promotion of majority language does not violate or average the provisions protecting the interest of minorities. So statement 1 is not correct. Now Article 29 provides that any section of citizens residing in any part of India having a distinct language, script or culture of its own shall have the right to conserve it, thereby protecting the culture and linguistic rights of groups, including minorities. It further states that no citizen shall be denied admission into any educational institution maintained by state or receiving state aid on the grounds only of religion, race, caste, or language, though admission may be restricted on other grounds such as place of birth. This does not infringe upon the protection of minority interests, as the first provision safeguards group rights while the second guarantees individual rights irrespective of community. So statement 2 is not correct. Now we have certain additional information. So right of minorities to establish and administer educational institutions. So right of minorities to establish and administer educational institutions. So basically Article 30 grants the following rights to minorities, whether religious or linguistic. Okay, so two types of minorities that is envisaged in the constitution, linguistic and the religious. So all minorities under Article 30 shall have the right to establish and administer education institution of their choice. The compensation amount fixed by the state for the compulsory acquisition of any property of minority education institution shall not restrict or abrogate the right granted to them. The provision was added by 44th Constitutional Amendment Act of 1978 to protect the rights of minorities in this regard. In granting it, the state shall not discriminate against any education institution managed by a minority. Thus, the protection under Article 30 is confined only to minorities, religious or linguistic, and does not extend to any section of society under Article 29. However, the term minority has not been defined anywhere in the Constitution. The right under Article 30 has also includes the right of minority to impart education to its children in its own language. Minority education institutions are of three types. So, institutions that seek recognition as well as aid from the state, institutions that seek only recognition from the state and not aid, institutions that neither seek recognition nor aid from the state. The institutions of the first and the second type are subject to regulatory power of the state with regard to syllabus prescription, academic standard, discipline, sanitation, employment of teaching staff, and so on. The institutions of the third type are free to administer their affairs but subject to the operation of general laws like contract law, labor law, industrial law, tax law, economic regulation, and so on. Now, let us see the next question number 54. Where an appeal or provision or revision is provided against an order passed by a court, tribunal, or any other authority before superior forum, and such superior forum modifies, reverses, or affirms the decision put in issue before it, the decision of the subordinate forum merges in the decision by the superior forum, and it is later which subsists, remains operative, and is capable of enforcement in the eye of law. So which of the following judicial doctrine is mentioned above the passage? So it is the doctrine of merger. So let us see this. So, doctrine of merger or the merger doctrine in civil proceedings is a common law doctrine that stems from the idea of maintaining the decorum of the hierarchy of courts and tribunals. The superior jurisdiction should be capable of reversing, modifying, or affirming the order put in the issue before it. Under Article 136 of the Constitution, the Supreme Court may reverse, modify, or affirm the judgment, decree, or order appeal against against while exercising its appellate jurisdiction and not while exercising the discretionary jurisdiction, disposing of petition for several for a special leave to appeal. The Supreme Court sum up the meaning of the doctrine of merger was in the case of Kanhaiya Mayor, the overseas state of Kerala, wherein the court in the judgment held that the where an appeal or revision is provided against an order passed by a court, tribunal, or any other authority before the superior forum, and such superior forum modifies, reverses, or affirms a decision put in issue before it. The decision by the subordinate forum merges in the decision by the superior forum, and it is the latter which subsists, remains operative, and is capable of enforcement in the eye of the law. So option B is correct. Now additional information. Now doctrine of pith and substance. So doctrine of pith and substance state that if the substance of legislation falls within the legislature's lawful power, the legislation does not become unconstitutional just because it impacts an issue beyond its area of authority. True nature and character is what the phrase pith and substance signifies. The infringement of the constitutional delimitation of legislative powers in a federal state is the subject of this concept. The court uses it to determine whether the claimed intrusion is just incidental or significant. Thus, the pith and substance concept holds that the challenged statute is fundamentally within the legislative competence of the legislature that enacted it, but only incidentally encroaches on the legislative field of another legislature. Now, doctrine of eclipse. So, the doctrine of eclipse is a significant in Indian constitutional law that deals with the relationship between constitutional law and the fundamental rights enshrined in the Constitution. The doctrine provides a framework to address inconsistencies between pre-existing laws and the Constitution mandates, ensuring that such laws are not rendered entirely void but are temporarily inoperative until the inconsistency is resolved. Now, doctrine of harmonious construction. The doctrine of harmonious construction means that when a conflict arises between different statutes or between statutes, in such circumstances, court try to interpret them in a way that makes them work together smoothly instead of declaring other statutes void. The main aim of this doctrine is to give effect to all provisions while maintaining the overall coherence and the purpose of the law. Now, question number 55. Under Article 341 of the Indian Constitution, which among the following authorities are empowered to recognize a caste, race, or tribe as a scheduled caste? So, this is the President of India who has the authority or the power to recognize a caste, race, or tribe as a scheduled caste. Okay, so let us see the constitution scheme. So, as per Article 341, Clause 1 of the Indian Constitution, the President may, with respect to any state or union territory, where it is a state after it is a state after consultation with the governor thereof by public notification, they specify the caste, races, or tribes or parts of or a group within caste, races, or tribes which shall, for the purposes of the constitution, be deemed to be scheduled caste in relation to that state or union territory as may be as case may be. As per Article 341, Clause 2 of the Indian Constitution, Parliament may by law include in or exclude from the list of scheduled castes specified in a notification issued under Clause 1 any caste, race, or tribe or part of or group within any caste, race, or tribe, but except as aforesaid, a notification issued under the said clause shall not be varied by any subsequent notification. Thus, the President of India and the Parliament are empowered to recognize a caste, race, or a tribe as a scheduled caste. Okay, so option C is the correct answer. Okay, so that is the thing. Now, Additional information about Article 341 and 342 of the Indian Constitution about. See, the Indian Constitution provides for the recognition and protection of the scheduled caste and the scheduled tribes. Article 341 of the Indian Constitution deal with the scheduled caste, while Article 342 deals with the scheduled tribes. Based on the advice and recommendations of the Governor of a state, President of India has the power to notify particular caste or tribes as scheduled caste or scheduled tribes. Okay, so the recommendation and the advice of the governor is the ground on which person declare any state or any area of the state, sorry, any caste of a particular area of a state or area to be the scheduled caste or to be part of scheduled caste or the scheduled tribe. Now, Article 342. So, provision in Article 342 deals with the president. The president may, with respect to any state or union territory, and where it is a state, after consultation with the governor thereof, by public notification, specifies the tribes or tribal communities or parts of a group or groups within tribes or tribal communities which shall, for the purposes of the constitution, be deemed to be scheduled tribes in relation to that state or union territory as the case may be. Parliament may by law include in or exclude from the list of scheduled tribes specified in notification should under clause 1 any tribe or tribal community or part of or group within any tribe or tribal community, but save as aforesaid, a notification issued under the said clause shall not be valid by any subsequent notification. Now, next question, question number 56. With reference to the devolution of resources to panchayats, consider the following statement. States are not mandated to grant the financial power to collect taxes to panchayats. Yes, this is absolutely correct. Panchayats may receive grants from the union government as per the recommendation of the Central Finance Commission. Yes, that is also true. Karnataka ranks first in the Panchayat Devolution Index 2024. I don't know about this. So 1 and 2 we know. So 1 and 2. So they are stating these as the correct. So it means that Karnataka ranks first in the Panchayat Devolution Index 2024. Now, Panchayat being local government is a state subject. It is a state subject and part of the state list of the seventh schedule of the Constitution. State list of the seventh schedule of the Constitution. Mandate for setting up a panchayat is provided by Article 243 in Part 9 of the Constitution of India. For financial empowerment of the panchayats, provisions have been made in terms of Article 243H, Article 280, Clause 3, Subclause BB, and 243I of the Constitution. In terms of Article 243H, the state legislatures may by law authorize the panchayat to levy, collect, and appropriate taxes, duties, tolls, and fees assigned to the panchayat, such as taxes, duties, tolls, and fees subject to conditions and limits. Provide for grants in aid to the panchayats from the consolidated fund of state and creates its own fund to credit its money. Now, Article 280 provides for a finance commission as a quasi-judicial body. It is constituted by the president every fifth year or even earlier. The funds recommended by the Union Finance Commission are transferred to the states to augment their finances in order to supplement the resources of rural local bodies, panchayats. These funds are transferred from the union government to the state governments. From the states, they are then transferred to individual RLVs. These transfers are governed by stipulations and conditions that may be imposed by the union government, which in turn may not be based on recommendations of the Finance Commission. Thus, panchayats may receive grants from the union government as per the recommendation of the Union Finance Commission. Now, devolution index presents the overall scores and ranks for the UTs, states, and the UTs on six identified dimensions. For among functions, finances, functionaries, capacity, enhancement, and accountability. Based on the weighted aggregation of six dimensions of indices of recent Panchayat Devolution Index 2025-24, a state of Karnataka ranks first in the present ranking with an index of 89, and followed by Kerala, Tamil Nadu, Maharashtra, and fifth the state of Uttar Pradesh. Now, devolution of powers and resources. The Government of India introduced the Panchayats Empowerment and Accountability Incentive, pays with objective incentivize states to empower the states and intensivize panchayats to put in place accountability system to make their functioning transparent and efficient. In 2012, the study went beyond the dimension of four F's: framework, functions, finance, and functionaries, and two new dimensions were added: capacity building and accountability. Now rankings, states namely Tripura, Rajasthan, West Bengal, Chhattisgarh, Telangana, Andhra Pradesh, Himachal Pradesh, Madhya Pradesh, and Odisha are above 50. State of Bihar, along with the northern, northeastern, and the hilly states of Assam. So this is not important. Now next question: which of the following best describe the horizontal application of the fundamental rights? So it can be enforced against other citizens. So horizontal application of the fundamental rights. Now the doctrine of horizontal and vertical application of rights delineate the scope and enforcement of the fundamental rights within the legal system. In India, these doctrines determine whether individuals can invoke constitutional rights solely against the state vertical application, or also against other private individual and entities horizontal application. Vertical application of the rights. This traditional approach allows individual to enforce fundamental rights against the state or its instrumentalities. The Indian Constitution primarily envisages this model where citizens can seek protection from state action that infringe upon their rights. For instance, Article 12 defines the state encompassing the government bodies against which fundamental rights can be claimed. Now, horizontal application of rights enforced against other citizens, non-state private actor as well. This concept extends the enforcement of the fundamental rights to disputes between private individuals or entities. It posits that certain rights should be upheld not only in public sphere but also in private interactions. In Indian context, while the Constitution predominantly supports vertical application, certain provisions imply horizontal applicability. So option B is correct. Now legal provisions. So horizontal application. Article 52, 15.2 prohibits discrimination by the state and private individual concerning access to shops, public restaurants, hotels, and places of public entertainment. This article explicitly extends fundamental rights into the private domain, preventing discriminatory practices by private entities. Article 17 abolishes the untouchability and forbids its practice in any form. This provision applies horizontally, ensuring that private individuals do not engage in discriminatory practices based on untouchability. Article 23-24 prohibit human trafficking, forced labor, and child labor respectively. These articles are enforceable against both the state and private individuals, highlighting their horizontal applicability. Now, elements of horizontal application: constitutional provision. The Constitution must explicitly or implicitly allow for rights to be enforced against private individuals. Now, judicial interpretation: courts play a vital role in interpreting the extent to which rights apply horizontally. Legislative framework: laws enacted by legislature can facilitate the horizontal application of rights, such as anti-discrimination statutes. Now, question number 58. Consider the following statements. Statement first: Parliament has enacted the Interstate River Water Disputes Act 1956 for dispute resolution relating to waters of interstate rivers. Yes, that is correct. Water is under the Union list, subject of the seventh schedule of the Indian Constitution. No, this is not correct. So statement one is correct, and but statement two is not correct. So let us say the explanation. So Article 262 of the Constitution provides for the adjudication of interwater disputes. It's make two provision. Parliament may by law provide for the adjudication of any dispute or complaint with respect to the use, distribution, and control of waters of any interstate river and river valley. Parliament may also provide that neither the Supreme Court nor any other court is to exercise jurisdiction in respect of any such dispute or complaint. Under this provision, the Parliament has enacted two laws: the River Boards Act 1956 and the Interstate Water Disputes Act 1956. The River Boards Act provides for the establishment of river boards for regulation and development of interstate rivers and river valleys. A river board is established by central government on the request of the state governments concerned to advise them. The Interstate Water Dispute Act 1956 empowers the central government to set up ad hoc tribunal for adjudication of a dispute between two or more states in relation to the waters of an interstate river or river valley. The decision of tribunal would be final and binding on parties to the dispute. Neither the Supreme Court nor the decision of tribunal would be final and binding on the parties to the dispute. Neither the Supreme Court nor any other court is to have jurisdiction in respect of any water dispute which may be referred to such tribunal under this act. So statement one is correct. Water is a subject under state list of the seventh schedule of the Constitution. What is to say water supplies. That is to say water supplies. Irrigation and canals, drainage and embankments, water storage and water power subject to the provision of 2056 of the union list comes under the state subject. This means that the states generally have the power to make laws about water supply, irrigation, canals, drainage, embankments, storage, and water power. However, this is subject to 2056 of the union list, meaning the union parliament can step in for interstate matters. So, statement 2 is not correct. Now, let us see the additional information. So, interstate trade and commerce about Article 301 to 307 of the Constitution deal with trade, commerce, and intercourse within India. Article 301 grants freedom of trade, commerce, and intercourse throughout India, both interstate and intrastate, aiming to remove barriers between the states. This freedom is subject only to restrictions provided in Articles 302 to 305. Parliament can impose restrictions in the public interest, but cannot discriminate. Impose restriction in the public interest, but cannot discriminate between states except in case of scarcity. State legislature can impose reasonable restrictions in public interest, but only with the precedent prior sanctions and cannot favor one state over other. States may levy taxes on imported goods equal to local goods, preventing discriminatory taxation. So states may levy taxes on imported goods equal to local goods, preventing discriminatory taxation. Now, next question. Consider the following statements. How many of the above statement is are correct? Census is a part of concrete list under the seventh schedule of the Constitution. No, this is not part of concrete list, which means that the state and the center both can make the law on the census. No, this is exclusively the domain of the union government, which means it is a part of the union list. So this is incorrect. The Office of Registrar General and Census Commission is empowered to implement the census in India. Yes, correct. The 16th census will be the India's first digital census, and it will be enable self-enumeration by the public. Yes, this is also correct. So both of them are correct, while one is incorrect. So only two are the correct. So let us see the explanation. So the population census is a union list, and the Ministry of Home Affairs is in charge of this subject. It is listed at serial number 69 in the 7th schedule of the Article 256 of the Constitution of India. The population census is taken as per the provisions of the Census Act 1968, which empowers the central government to conduct a census of the population of the country after duly notifying it. Though the census is a union subject, the actual conduct of the Indian census has always been the joint endeavor of both the central and the state governments. The entire field operation, which includes house listing, population enumeration, are recognized through the general administrative machinery of the states at various levels. At the state and the union level, the director of census operation appointed under the Census Act is responsible for organizing and supervising the census operations within his state and UT. Hence, census is a union list not listed on the concurrent list under the seventh schedule of the Constitution. So, statement one is not correct. The responsibility to conduct the decennial population census under the Census Act lies with the Office of Registrar General and Census Commissioner, India. It is responsible for the following: housing and population census, national population register (NPR), civil registration system (CRS), sample registration system (SRS), mother tongue survey, and linguistic survey. So statement 2 is correct. The government has formally announced that the 16 census of India will take place in two phases, with the reference dates set as March 1st, 2027 for most of the country. The process is carried out in two broad phases: the house listing and housing census, followed by the population enumeration. The 2027 census will be the first digital census in India's history, with the use of mobile apps, online self enumeration, near real time monitoring. It is also the first since 1931 that will collect caste data for all communities. So statement 3 is correct. Now certain additional information regarding census 2027. Recently in news, population census 2027 to be conducted in two phases along with the enumeration of caste. So enumeration of caste is included. About the census serves the multiple critical functions. It is the basis on which electoral constituencies are drawn and seats are reserved for scheduled castes and scheduled tribes. Central grants to states and districts are often population based, as are subsidies and ration allocations. Ministries ranging from education to rural development use census data to locate schools, primary health centers, and infrastructure projects. It helps the judiciary, planners, and scholars alike understand trends in migration, urbanization, employment, and fertility. The census is also crucial to the implementation of constitutional provisions. Article 82 of the Constitution mandates delimitation of constituency based on the most recent census. So, Article 82 of the Constitution mandates a delimitation of constituency based on the most recent census. Article 330 and 332 reserve seats for SCs and STs in legislature based on their population proportions. Now, process and technology, apart from the process being digital, allowing self enumeration, census 2027 will include GPS integration, while 2011 used physical maps and area list. 2027 introduces GPS tagging of households and geofencing to avoid coverage gaps. Okay, so now mobile tracking and validation. Now, enumerators in 2027 will receive alerts for error like inconsistent age or unrealistic household size, enabling real-time correction. Such checks did not exist in 2011. And now, coding system for 2027 census, the Registrar General of India has introduced a new coding system to make data collection more accurate and efficient. Earlier in 2011, census information like caste, occupation, or mother tongue was written by hand, often leading to spelling mistakes and confusion during data processing. Now, next question, question number 60, with reference to judges of Supreme Court of India, consider the following statements. They can hold office until they attain the age of 60 years. I think this is most likely incorrect because the maximum age of the judges of the Supreme Court is around 62 or 65 maybe. Let me check. Yes, so statement they have given statement one is incorrect. So I think I am right. Yes, 65 years. Yes, you will have 65 years, not 60 years. So this is incorrect. The president can issue a removal of a judge if the parliamentary address regarding the issue obtains a special majority support in both the house. Yes, that is true. In India, Supreme Court judges have not been impeached. Yes, that is absolutely true. So B and 3 are correct, while statement 1 is incorrect. So only B are the correct. Now explanation. Article 124 in the Constitution of India states there shall be a Supreme Court of India consisting of Chief Justice of India until Parliament by law prescribes a large number of not more than 7 other judges. Every judge of the Supreme Court shall be appointed by the President by warrant under his hand and seal after consultation with such of the judges of the Supreme Court and High Courts in the states as the person may deem necessary for that purpose, and shall hold office until he attains the age of 65 years, provided that the judge may by writing under his hand address to the person resign his office. A judge may be removed from his office in manner provided in clause 4. Clause 4. A judge of the Supreme Court shall not be removed from his office except by an order of the President passed passed after an address by each House of Parliament supported by a majority of the total membership of that House and by a majority of not less than two-thirds of the members of the House present and voting. Present and voting has been presented to a President in the session for such removal on the ground of proved misbehavior, misbehavior or incapacity. No judge of the Supreme Court has been impeached so far. The first case of impeachment is that of Justice V. Ramaswamy of Supreme Court, 1991-93. Though the inquiry committee found him guilty of misbehavior, he could not be removed as the impeachment mention was defeated in the Lok Sabha. So, statement he is correct. Additional information: Supreme Court. Recently news: the Union government is likely to bring an impeachment motion against an Allahabad High Court judge. About the Supreme Court of India. So see, this news is Allahabad High Court. Basically, this is related to the gas bundles of burned gas that was found in the residence of one of the then uh, judges of the High Court of Delhi. Okay, so now who has been now transferred to the Allahabad High Court. So that is what is this news all about. So about the Supreme Court of India was inaugurated on 20th January 1950. It succeeded the Federal Court of India established under the Government of India Act 1935. However, the jurisdiction of the Supreme Court is greater than that of its predecessor. This is because the Supreme Court has replaced the British Privy Council as the highest court of British Privy Council as the highest court of appeal. Articles 124 to 147 in part of the Constitution deal with the organization, independence, jurisdiction, powers, procedures, and so on of the Supreme Court. Parliament also authorized to regulate them. Now, procedure for the removal of the Supreme Court judges. So the Judges Inquiry Act 1968 regulates the procedure relating to the removal of a judge of the Supreme Court by the process of impeachment. So, removal motion signed by 100 members in case of the Lok Sabha or 50 members in case of the Rajya Sabha is to be given to the Speaker or Chairman. Okay, so removal motion is needed, which should be signed by 100 members in case of Lok Sabha and 50 members in case of Rajya Sabha, which should be given either to a Speaker or Chairman respectively. The Speaker or Chairman may admit the motion or refuse to admit it. Okay, if it is admitted, then the Speaker or Chairman is to constitute a three-member committee to investigate charges. The committee should consist of the Chief Justice or a judge of the Supreme Court, a Chief Justice of a High Court, and a distinguished jurist. If the committee finds the judge to be guilty of misbehavior or suffering from an incapacity, the House can take up the consideration of the motion. After the motion is passed by each House of Parliament by a special majority, an address is presented to President for removal of the judge. Finally, the President passes an order removing the judge. So this is the entire process of the removal of the Supreme Court judges under Judges Inquiry Act 1968. So let us recap once again. So a removal motion which should be signed by 100 members in case of the Lok Sabha or 50 members in case of the Rajya Sabha is to be given to the Speaker or Chairman respectively. The Speaker or Chairman may admit the motion or refuse to admit it. It is admitted, then the Speaker or Chairman is to constitute a three-member committee to investigate the charges. The committee should consist of a Chief Justice, the Chief Justice or a judge of the Supreme Court, B, a Chief Justice of a High Court, and C, a distinguished jurist. If the committee finds the judge to be guilty of misbehavior or suffering from incapacity, the House can take up the consideration for the motion. After the motion is passed by each House of Parliament by a special majority, an address is presented to the President for the removal of the judge. Finally, the President passes an order removing the judge. Okay, so we have already, I think, 10 days back, we have already covered this into our current affairs discussion of the Hindu. Okay, so you can also visit that discussion where we have comprehensively covered all these things. Okay, removal of a judge, of this judge. Okay, so that is the one of the uh, very good videos to understand Judges Inquiry Act. Okay, and removal process of the uh, judges of the Supreme Court. Okay, so you can visit that also. Anyway, question number 61. Consider the following statement. Any law passed by state legislature providing for taking over of management of any property by the state for a limited period in the public interest should receive the assent of the president. So let us see once again. Any law which is passed by the state legislature, yes, providing for the taking over of management of any property by the state for a limited period in the public interest should receive the assent of the person. I don't know about this. Any law passed by the state legislature that abridges any of the rights conferred by Article 19 for securing any of the principle laid in the Part 4 of the Constitution should receive the assent of the person. I don't know this also. So they have given statement one is as only the statement one as the correct. Let us see the explanation. Okay, so as per Article 31 Clause A, notwithstanding anything contained in Article 13, no law providing for taking over of management of any property by the state for a limited period, either in public interest or in order to secure the proper management of property, shall be deemed to be void on the ground that it is inconsistent with or takes away or abridges any of the rights conferred by Article 14 or Article 19, provided that where such law is a law made by legislature of a state, state, the provisions of this article shall not apply thereto unless such law having been reserved for the consideration of the president has received his assent. Now, Article 31C of the Indian Constitution was introduced to protect the laws implementing Article 39B and 39C of the DPSP, which aim at equitable distribution of resources and preventing concentration of wealth from being challenged under Article 14 and 19, though state laws still require presidential assent. The 42nd Amendment 1976 tried to extend this protection to all directive principles, making them superior to the fundamental rights, but the Supreme Court in Minerva Mills case 1980 struck down this as the unconstitutional, holding that it destroy the balance between Part 3 and Part 4 of which is part of the basic structure. Currently, only laws implementing Articles 39B and C enjoy protection under Article 31C with presidential assent. If passed by a state legislature, laws implementing the DPSP do not automatically require assent to abridge Article 19 rights. Thus, law passed by the state legislature restricting Article 19 for only certain sections of the Part 4 of the DPSP requires presidential assent. So, statement 2 is not correct. Now, let us look at the question number 62. Consider the following. Which among the above authorities have the power to remit sentences of convicts? So, who can remit the sentences of the convicts? So, President under Article 72, okay, Governor under Article 161, okay, and the state government as well, okay. So, for instance, the Mohan, I think Anand Mohan, who was a convict in the murder and in the brutal murder of sitting district magistrate uh, in Bihar was given the remit of the sentence was given the remit of his sentence by the Bihar government. Okay, so this is the correct answer. Now explanation. Article 72 of the Constitution empowers the president to grant pardon, reprieve, respite, and remission of punishment or suspend, remit, or commute the sentence of any person convicted of any offense in all cases where the punishment or sentence is by a court martial, where in all cases where the punishment or sentence is for an offense against union law, in all cases where the sentence is a sentence of death. Now remission, what is remission? So remission implies reducing the period of sentence without changing its character. For example, a sentence of rigorous imprisonment for 2 years may be remitted to rigorous imprisonment for 1 year. Therefore, the president has the power to remit sentences of convicts. So, statement 1 is correct. Now, Article 161 of the Constitution empowers the governor to pardon, deprive, remit, respite, suspend, or commute the punishment or sentence of any person convicted of an offense against the state law. The governor cannot pardon a death sentence. Even if a state law prescribes a death sentence, the power to grant a pardon lies with the president and not the governor. But the governor can suspend, remit, or commute a death sentence. So, statement 2 is correct. Now, the power of remission refers to the power to reduce the period of sentence for a person who has been found guilty of a crime. Section 473 of BNS and Section 432 of the CRPC grants state governments the power to remit sentences at any time. States can also choose whether to impose conditions that the convict must meet for her sentence to be remitted, such as agreeing to report to a police officer at regular intervals. If any of these conditions are not fulfilled, the provision states that the states may cancel the remission granted and arrest the convict against without a warrant. This is this is separate from the power of president and the governor to remit sentences under Article 72 and 161 of the Constitution, respectively. So, statement 3 is correct. Now, there are certain additional information that we should look at. So, types of pardons. So, recently in news, so the Supreme Court ruled that the states with the remission policies must consider releasing prisoners early, even if they don't apply for it. Certain convicts are excluded. Early release is allowed under the Bharatiya Nyaya Suraksha Samhita 2023 BNSS and the Code of Criminal Procedure 1973 CRPC. Pardon. It removes both the sentence and the conviction completely, absolving the convict from all sentences, punishments, and disqualification. Now, commutation. It denotes the substitution of one form of punishment for a lighter form. For example, this sentence may be commuted to rigorous imprisonment, which may in turn may be commuted to the simple imprisonment. Remission, it implies reducing the period of sentence without changing its character. For example, a sentence of rigorous imprisonment for 2 years may be remitted to rigorous imprisonment for 1 year. Despite it denotes awarding a lesser sentence in place of one originally awarded due to some special fact, such as the physical disability of a convict or the pregnancy of a women offender. Reprieve, it implies a stay of the execution of a sentence, especially that of death, for a temporary period. Its a purpose is to enable the convict to have time to seek pardon or commutation from the president. Now, question number 63. Consider the following: how many of the pairs above is are correct? Okay, so you have habeas corpus, prohibition, and covenant. Now, habeas corpus to have the body of yes, this is correct. Can be issued by High Court irrespective of the jurisdiction. Yes, that is also true. Prohibition yes to provide. So it is basically directs inactivity on the part of lower judicial courts. It means that the higher judiciary, higher court, for example, Supreme Court can forbid or directs the lower court or high court to not exceed its jurisdiction. Okay, quo warranto by what authority or why or warrant can be invoked by anyone, or not necessarily the aggrieved person. Okay, so all of them are correct. Hence, so let us see the explanation. So Articles 32 confers the right to remedies for the enforcement of the fundamental rights of an aggrieved citizen. Therefore, the right to get fundamental rights protected as is in itself a fundamental right. The Supreme Court under Article 32 and High Court under Article 226 can issue writs of habeas corpus, mandamus, certiorari, and quo warranto. Further, the Parliament under Article 32 can empower any other court to issue these writs. Okay, so it is the Parliament which can empower any other court to issue these writs. Since no such provision has been made so far, only the Supreme Court and High Courts can issue the writs and not any other court. Habeas corpus is a Latin term which literally means to have the body of. To have the body of. It is an order. It is an order issued by the court to a person who has detained another person to produce the body of the latter before it. The court then examines the cause and legality of the detention. It would set the detained person free if the detention is found to be illegal. Thus, this it is a bulwark of the individual liberty against arbitrary detention. The writ of habeas corpus can be issued against both writ of habeas corpus can be issued against both public authorities and private individuals. The writ, on the other hand, is not issued where the detention is lawful. The proceeding is for the contempt of legislature or the court. Detention is by a competent court, and detention is outside the jurisdiction of the court. Therefore, habeas corpus can be issued by the High Court within its jurisdiction. So pair one is not correct. So pair one is not correct. So how many of our do you have the can be so irrespective of their jurisdiction? Oh, irrespective of no within their jurisdiction. So one is incorrect. So habeas corpus one is incorrect. So I think they have marked wrong thing. So here only two are correct, not all the three. Only two are correct. So irrespective they have given. So irrespective not within their jurisdiction. Okay. So pair one is incorrect. So now let us see the prohibition. Prohibition literally means to forbid. It is issued by a higher court to a lower court or tribunal to prevent the latter from exceeding its jurisdiction or usurping a jurisdiction that it does not possess. Thus, unlike mandamus, which directs activity, the prohibition directs inactivity. The writ of prohibition can be issued against only against judicial and quasi-judicial authorities. It is not available against administrative authorities, legislative bodies, or private individuals or bodies. Therefore, prohibition directs inactivity on part of the lower judicial courts by higher court. Now let us see the quo warranto. Quo warranto means by what authority or warrant. It is issued by court to inquire into the legality of a person holding public office. Hence, it prevents illegal usurpation of public office by a person. The writ can be issued only in case of substantive public office of a permanent character created by a statute or by the constitution. It cannot be issued in cases involving a ministerial or private office. Unlike the other four writs, any interested person can seek this and not necessarily by the aggrieved person. Okay, so anyone can seek this, not necessarily the aggrieved person. Therefore, the quo warranto can be invoked by anyone, not necessarily by the aggrieved person. Now, additional information. So, other writs. So, mandamus means we command a command issued by the court to public official asking him to perform his official duties that he has failed or refused to perform can also be issued against a public body corporation in inferior court tribunal or the government cannot be issued against a private individual or body to enforce departmental instruction without a statutory force when the duty is discretionary and not mandatory to enforce a contractual obligation against the President of India or the state governors against the Chief Justice of a High Court and when acting in judicial capacity. Now, such certiorari to be certified to be informed issued by a higher court to the lower court or tribunal can be used to transfer a case pending with the lower court or to quash its order issued on the grounds of excess of jurisdiction, lack of jurisdiction, error of law. Unlike prohibition, which is preventive, statutory is both preventive and curative. Earlier, it applied only to judicial or quasi-judicial authorities. In 1991, the Supreme Court held that it can also be issued against administrative authorities affecting the rights of individuals. Now it cannot be issued against legislative bodies or private individual bodies. Now 64. With reference to the Meri Panchayat application, consider the following statements. It is a joint initiative by the Ministry of Panchayat Raj and National Informatics Center under the Ministry of Electronics and Information Technology. It provides Panchayat a specific weather forecast. It gives access to Panchayat budgets and development So this is giving all of them as the correct. Let us see. So मेरी पंचायत है for the governance platform for Panchayat of India empowers over 25 lakh elected representatives and approximately 950 million rural residents across India's 2.65 lakh Gram Panchayat, transforming rural governance through digital inclusion and transparency. It aims to create a unified mobile governance platform for rural areas, including residents, functionaries, and Panchayati Raj institutions a system's stakeholder. It seeks to streamline and consolidate various functions and information scattered across different portals into one cohesive mobile platform, thus serving the varied needs of Gram Panchayats. Additionally, the mobile app encourages a collaboration among stakeholders, cultivating an environment that supports efficient and panchayat governance. It is an initiative of the Ministry of Panchayati Raj and National Informatics Center (NIC) under the Ministry of Electronics and Information Technology. Okay, so leave this, not much important. Now, timely justice is essential to build public trust in the legal system. Prolonged delays may deter people from approaching courts. This hesitation to approach courts due to the high stress levels ordinary citizens experience in courtrooms is termed as black coat syndrome. Now let us see what is this. So recently, the President of India coined the phrase "black coat syndrome." Okay, black coat syndrome for the high stress levels or ordinary citizens experience in courtrooms. Timely justice is a cornerstone of public trust in the legal system, as captured by the classic maxim "justice delayed is justice denied." Prolonged delays often deter public people from approaching courts. Although this has been a perpetual issue in India, the scale is now striking. Over 86,700 cases are pending in the Supreme Court, over 63.3 lakh cases in high courts, and 4.6 crore cases in district and subordinate courts. So option 1 is correct. Additional improvement justice delivery timely. An analysis of the justice delivery timeline in Indian courts reveals stark disparities across court levels and case types as shown in the chart below. So this is so various reforms have been there. So this is not important particularly from the perspective of the police, but for the men this is relevant. Next question, question number 66. With reference to the Speaker of the Lok Sabha, consider the following statements. The Speaker acts like a tribunal while deciding question on the defection of a member of the Parliament. Yes, that is true. The Speaker's decision on defection is subject to judicial review. Yes, that is also true. The Speaker may disqualify a member of Parliament for disobeying his political party's direction. Yes, that is also correct. So all of them are correct. Let us see the explanation. Recently, the Supreme Court clarified that it is not powerless even if a speaker delays or remains indecisive on petitions seeking the disqualification of legislatures under 10th schedule under anti-defection law. India follows the Westminster model of the government where a speaker serves as the presiding officer of the Lok Sabha. The Constitution under Article 93 provides for the offices of the speaker and the deputy speaker. The speaker, the speaker, as the constitutional and ceremonial head of the House, is responsible for maintaining order and discipline in its proceedings. Under the 10th schedule, the speaker has always a quasi-judicial role in the deciding matters of the disqualification of members due to defection. Originally, the law stated that the speaker's decision was final and beyond judicial scrutiny. However, in Kuheto Havalan versus Jachilu 1992, the Supreme Court ruled that while a speaker acts as a tribunal in defection cases, his decisions are subject to judicial review on limited grounds, such as mala fights, perversity, violation of constitutional principles. So, statement 1 and 2 are correct. Now, the 10th schedule was inserted in the Constitution in 1985. It lays down the process by which legislatures may be disqualified on the grounds of defection by the presiding officer of legislature, chairman in the case of the Rajya Sabha, and the speaker in the case of the Lok Sabha, based on the petition by an other member of the House. A legislature is deemed to have defected if he either voluntarily gives up the membership of his party or disobeys the directives of the party leadership on a vote. This implies that the legislature defying or abstaining or voting against the party whip or on any issue can lose his membership of the House. The law applies to both Parliament and state assemblies. So additional information about anti-defection law. So 52nd, the 52nd Amendment Act 1985 introduced the 10th schedule to the Constitution, laying down provisions for the disqualification of MPs and MLAs on the ground of defection. This act is often referred as the anti-defection law. Now let us see the grounds for defection. Grounds for defection. Okay. Now a member is disqualified. A member is disqualified if he voluntarily gives up membership of his party, if he votes against or abstain from voting against the party whip without prior permission, and the party does not condone it within 15 days. An independent member is disqualified if he joins any political party after being elected. A nominated member may join a political party within 6 months of entering the House. Joining any party after 6 months attracts disqualification. Exception: disqualification does not apply in following cases: when at least two-thirds of the legislature party agrees to merge with another party. If a member is elected as Speaker, Chairman, and voluntarily gives up party membership during tenure or rejoins after leaving office. The 91st Amendment 2003. The 91st Amendment Act 2003 extended the anti-defection law by removing that protection available in the cases of a split. Earlier, a split of one-third of the members of legislative party was a valid defense against disqualification. The amendment removed this exception, ensuring defectors no longer enjoy protection on the grounds of a split. Okay. Now, next question, which is question number 67. With reference to the Indian polity, consider the following information. Now, there are provision and they are stated under. So, rights of detain, uh, detain. So, it is under fundamental rights, yes, under Article 22. Okay. So, basically, preventive detention. It is under preventive detention. The rights of detainee. The person means the person who has been detained. Okay. Now, second, defend the country and render national service when called upon to do so. Fundamental duties, yes, correct. Uniform Civil Code, directive principle of state, yes, UCC, and Article 44. Now, let us see the explanation. So, all of them are correct. See explanation. Recently, the Supreme Court of India intervened in the case in a case where a person was detained under the anti-defection, anti-smuggling law, but the jail authorities delayed sending his representation, a petition challenging the detention for 9 months. When a person is kept in custody and their freedom is taken away, but not because they have been convicted of a crime, they are said to be in detention, and such a person is called a detainee. To protect their rights and prevent misuse of power by the police, the Constitution of India provides important safeguards. Article 21 says no person can be deprived of their life or personal freedom except according to the law. This means any arrest or detention must follow proper legal procedures. Now, Article 22 gives a special protection to people who are arrested or detained. It ensures that detainees are informed of the reasons for their arrest, have the right to consult a lawyer, and are treated fairly. Their these constitutional provisions make sure that detention is lawful and that the personal liberties of a person is protected. So, pair one is correct. The 42nd Amendment of the Constitution 1976 introduced fundamental duties of the citizens. So 42nd Amendment Act of 1976 introduced the fundamental duties of the citizens, which are listed under Article 51A in Part 4A of the Constitution. These duties remind every citizen of their responsibility towards the nation. They include abiding by the Constitution, respecting its ideals, and cherishing the noble values of India's freedom struggle, promoting harmony and brotherhood beyond religious, linguistic, regional, or sexual differences, and defending the country. Defending the nation and performing a national service when required is recognized as a fundamental duty of every citizen under Article 51A. In a historic move, Uttarakhand has become the first state in India to implement the Uniform Civil Code UCC. The Uniform Civil Code UCC comes under Article 64 or 44 of the Indian Constitution, which refers to directive principles of the state policy. Article 44 provides that the state shall undertake to offer a unified sets of law to its citizens within the Indian boundaries. The Constitution of India provides that the directive principles of the state policy (TPSP) are not enforceable in legal terms, but can always be considered a guiding principle for the government. And thus, although the Constitution provides that the uniform code should be implemented, it does not make its implementation mandatory. Now, additional information. So, rights of detainee about the term detainees under Article 22 refers to two main categories of people: those kept in police custody while waiting to be brought before a magistrate on formal charges, or those awaiting trial but unable to get bail, those held under a special preventive detention law. Now, rights of detainees in India. So, right to know the reason for arrest, inform in a language understood, right to a lawyer, consult one of choice, free legal aid if unable to afford, right to be produced before the magistrate within 24 hours of arrest, right to medical examination, female detainees examined by female doctors, right to bail, informed and allowed to bailable offences, right to speedy trials, cases should be disposed of quickly, right against self incrimination, cannot be forced to testify against oneself. Rights of detainees under preventive detention. Review by advisory board. Detention beyond 3 months must be reviewed by a board of judges. Right to no grounds of detention informed within supporting documents in a known language. Right to make representation, can challenge detention. Authorities must consider it promptly. Now, question number 68. With reference to standing, the Standing Committee on Rural Development and Panchayati Raj consider the following statements. It has, I don't know about this, so we'll see the full explanation. Okay, so a full-fledged system of departmentally related standing committee (DRC) covering all ministries, departments of the government of India under their jurisdiction was formally created in 1993. The Standing Committee on Rural Development was uh, bifurcated into two committees: Standing Committee on Rural Development and a Standing Committee of Urban Development. The Standing Committee on Rural Development and Panchayati Raj consists of 31 members, 21 members from the Lok Sabha nominated by the Speaker, and and 10 from Rajya Sabha nominated by the Chairman. A minister is not nominated as the member of the committee. So statement 1 is correct. The chairman of the committee is appointed by the Speaker from amongst the members of the committee from the Lok Sabha. The term of office of the members of the committee does not exceed 1 year. So statement 2 is correct. Now, a Standing Committee on Rural Development and Panchayati Raj transacts the following functions with respect to the aforesaid ministries or departments under its jurisdiction: to consider the demands for grants and make reports on the same to the houses, to examine such bills as referred to by the committee by the Speaker, Lok Sabha, or the Chairman, Rajya Sabha, as the case may be, and to make reports thereon, to consider annual reports of the concerned ministry departments and make reports thereon, and to consider national basic long-term policy documents presented to the houses if referred to the committee by the Speaker, Lok Sabha, Chairman, Rajya Sabha, as the case may be, and to make reports thereon. This committee examines demands for grants but cannot suggest cut motions. Cut motions can only be moved in the Lok Sabha by the members of parliament, not by the committees. The Standing Committee on the Rural Development Panchayati Raj cannot recommend cut motions on demands for grants by concerned ministries. Now, a Standing Committee on Rural Development will not consider this. Now, question number 69. With reference to the Waqf Amendment Bill 2027, consider the following statements. It mandates the inclusion of women and non-Muslim in the Central Waqf Council. Yes, that is true. Appeals on orders of Tribunal for Waqf dispute lie exclusively with the Supreme Court. I don't know about this. So let us see. Recently, the Rajya Sabha has passed Waqf Amendment Bill 2005, which aims to update the Waqf Act to 1995 to fix issues in the management of Waqf properties. Under the Act, the Union Minister in charge of Waqf is the ex officio officio chairman of the council. Uh, Members of the council include members of the parliament, persons of national eminence, retired Supreme Court for or the High Court judges, and the eminent scholars in the Muslim law. The act requires all council members, barring the minister, must be Muslims. At least two must be women. The bill removes the requirement for the MPs, former judges, and the eminent persons and persons to be to the Muslims. Okay, to be the Muslims. So this is the thing. This expands judicial oversight and ensure that the parties dissatisfied with the tribunal decision have the statutory right to appeal rather than relying solely on the discretionary review by the High Court. Okay. Originally under the 1995 of Act, the decision of tribunal were given for finality. No appeals could be made in the regular courts. However, the High Court retained limited powers of review either on its own or on an application made by the board or any active party. The 2025 Fourth Amendment will seek to change this framework. It removes the provision that gave tribunal decisions absolute finality. Instead, it provides that the orders of tribunal can now be appealed before the High Court within a period of 90 days. Okay, now let us see the additional information not important. Now the last question for today's discussion. Okay, question number 70. Consider the following statements. Consider the following statements. India has conducted simultaneous election only three times since its independence. No, this is incorrect. The Joint Parliamentary Committee on the One Nation One election has a majority of its members from the Lok Sabha. That is true. So only B is the correct explanation. Simultaneous election, popularly referred to as One Nation One election, mean holding elections to the Lok Sabha and state legislative assemblies at urban and local bodies, municipalities, and panchayat at the same time. From 1951 to 1961, Lok Sabha and state legislative assemblies were held simultaneously. 1951, 52, 57, 62, 67. This cycle was broken in 1968-69 due to the premature dissolution of some state assemblies. The fourth Lok Sabha was dissolved early in 1970, leading to fresh election in 1971. Fifth Lok Sabha completed an extended term until 1977 due to emergency. Therefore, India has conducted simultaneous elections four times: 1951, 1970, 57, 62, and 67 since its independence. So, estimate one is not correct. Now, the Joint Parliamentary Committee on One Nation One Election, chaired by former President Ramnath Kovind, was established in September 2023 to examine and make recommendations for holding simultaneous election to the Lok Sabha, state assemblies, and local bodies. A joint parliamentary committee (JPC) is formed by the parliament for a specific purpose, such as detailed scrutiny of a subject or bill, and includes members from both the houses and from both ruling and opposite parties. The 39-member committee had a majority of its members from the Lok Sabha, with 27 from the Lok Sabha and 12 from the Rajya Sabha. So statement 2 is correct. One nation, one election. So the Union Cabinet recently approved the One Nation, One Election proposal, which aims to conduct simultaneous Lok Sabha and assembly election followed by urban body and panchayat votes within 100 days. About the proposal is based on the recommendation of high-level committee led by former President Ramnath Kovind, who submitted a detailed report on the subject. The report from the COVID-led committee highlighted the drawbacks of the frequent elections, saying that they often create an atmosphere of uncertainty. So, the comprehensive report spanning this must be the committee has recommended two-step approach, suggesting that the election for Lok Sabha and state assemblies to be conducted initially, followed by the election to the municipality and panchayat within 100 days thereafter. The committee has recommended that if a state assembly is dissolved due to no confidence motion, or in case of House fresh election may be held for the remaining term, aligning with that of the Lok Sabha. The panel has also recommended the preparation of the single electoral roll and electoral voter identity cards (EPIC) by the Election Commission of India in consultation with the State Election Commission. That's all for our today's discussion. We'll meet from we'll start discussion from 71 from the next time. Next time. Okay. Thank you very much.